Mr. Shattuck and Ms. Baker, we have 6 questions that you each will answer. We will alternate who begins. Let's start with the first question, and Mr. Shattuck. What factors should a prosecutor consider when deciding whether or not to prosecute a particular case?
Repeat that one time for me.
What factors should a prosecutor consider when deciding whether or not to prosecute a particular case?
Well, you need to look into what evidence there is and how successful you believe the case is going to be ultimately, how much time it's going to take up, and what result you would like to achieve at the end. And essentially, you also got to look to see whether you think the individual is guilty of the crime or not. That's one of my issues right now is case evaluation. We want to look at the cases as early as possible, look for all the evidence, make sure we've got all that together before you proceed. Because if you don't, then you end up wasting a lot of the taxpayers' money, time, and effort, basically, the court staff, law enforcement, and essentially the victims and witnesses.
Same question for you.
First off, thank you all for coming tonight and coming out on your own time to listen to us at this forum. We certainly appreciate it. Hopefully everyone will be able to make an informed decision after this. The factors that we need to consider when we decide to prosecute a certain case. First and foremost, Mr. Shattuck's right. You consider the facts. In the solicitor's office, when a case file comes in, the first thing we do is we look to see what elements of the crime are there and what may not be there. Before the case is ever signed or filed with the clerk, we make a determination of whether we think we can proceed with the charges as is. If we cannot, we go back and we amend, change, add, or even delete some of the charges that have been filed. And that's the way it typically works. Now, on a much larger scale, there are a couple more factors in play. Prosecuting a case in state court isn't what you think of as a normal old-time court, jail, probation, that kind of thing. There are a lot of other factors that we consider about what we're going to do with a case. We deal with misdemeanors. Misdemeanors sometimes mean there's a very violent offender, and we want to make sure that society is safe from them. But a lot of times, we have people who have just made a bad decision. And what we want to do is try to figure out what the underlying problem is, address it in any way, shape, or form that we can, whether it's education, whether it's substance abuse, whether it's that they grew up in a home where their father beat their mother every day. We can address these things, and we are. But those kinds of things also determine how we prosecute the case, whether it's prosecuted in the normal route or an alternative route through pretrial diversions, drug courts, domestic violence courts, and the like. Thank you.
Mr. Baker's question now. In Georgia, we say that the prosecutor represents the state. In some states, they say that the prosecutor represents the people. Some believe that the prosecutor represents the law enforcement officials. Who do you think the Solicitor General represents, and how does that belief affect your decisions?
Well, our accusations are the charging document. The accusation is what is signed and filed with the clerk, and it is styled the state of Georgia versus, and then the defendant's name. So if you look at it purely on the surface, we're representing the state as the prosecuting attorney. But here's where it also can get a little tricky. When you think about lawyers, you think about people who represent somebody more or less in a civil sense. In a domestic case, you have one side versus the other. It's not always like that when we prosecute criminal cases. What I'm looking for is the truth, period. And it may be absolutely different than what we thought it was to begin with. That happens sometimes. We have victims who come in who do not want a case prosecuted. If I were their civil attorney, I would have to go with what they said. I don't have to because I represent the state. I represent the people of this county. What I want to make sure is the right thing happens. That may not be just dropping the case if that's what the victim wants. So we look at all these kinds of things, but I think you've really got to think about what it is and what it means in terms of to represent someone. We represent the county, and we try to make sure that the right thing happens, but it isn't in terms of representing a victim like you would think of representation in a normal, legal, civil sense.
Mr. Shannon.
I agree with a lot of what Ms. Baker has to say, but in addition to that, I believe that you truly represent the victim in a criminal case. you want to try to get the best result of that victim you can, whether it's something stolen from them, you want to try to get restitution back, and even try to get the property back if you can. If it's a domestic violence situation, you not only represent that victim, but you represent any other victim that defendant, if the case is not prosecuted correctly, could reach out to the next time. So in a way, you're representing the community in addition to that victim that's currently before you. And so to do that, there's a lot of things that go into that situation, as Ms. Baker was talking about. You've got to look at the facts of the case, what you can do to win or lose the case, and what's the best result, what is best going to serve this victim that is currently in front of you. A lot of times, you don't want to send the defendant to prison. You don't want to send him to the county jail because that's not going to help the victim. So you have to fashion a result that best helps the victim while achieving the results that you want.
This question is beginning with you. How do you think Governor Deal's criminal justice reform legislation will affect the work of the Solicitor General?
I think it will increase the work of the Solicitor's office. There's a lot of laws that he has reduced the sentencing guidelines on, and I think it was purely to try to alleviate some of the prison system. The state of Georgia cannot continue to send individuals to prison. There's not enough space for them there. And so with that in mind, they basically lowered the punishments for some crimes. A lot of those happen to be your bad checks, which used to be felonies are now misdemeanors. They raised the limits on what a bad check is, or whether it's a felony or misdemeanor. Your forgeries, and there's several others, but that's essentially what was done. Like I said, I think it will increase. It's going to mean more hard work for the Solicitor's office. It's going to mean more time away from your family, because you're going to be in court a lot more. You're going to be prosecuting more cases. You're going to need more cooperation from law enforcement. And I think you need to have a good relationship with law enforcement to reach the proper results.
I sat on the Georgia Bar's Committee on Criminal Justice Reform. I was appointed by the past president of the state bar. He was down trying a jury trial in Troup County for about a week, and I think he saw a lot of the things that we were doing differently. What I found when I went up to these meetings was that we are quite advanced in Troup County in terms of criminal justice reform. A lot of the ideas that we had already put into place, people around the state were just thinking about. And I was very proud of what we've accomplished in the state board of Troup County as far as that's concerned. We had budget conferences just recently, and one of the things I was talking about with the county manager and county clerk had to do with this idea that the threshold level for misdemeanors was going to be increased in certain crimes. For some thefts, it's up to $1,500 now. For shoplifting, it went from $300 to $500. For deposit account frauds, it went up to $1,500. And there's some forgeries now that are going to be misdemeanors. We weren't able to put some good numbers on it, but my colleague, the Solicitor General for Psych, was. She did a 2-year look back, and she was able to say that they expect about an 18% increase per year in their workload. That's a pretty significant amount. So we used that in terms of our budget discussions as the time went on. In the Criminal Justice Reform Act, though, there is $11 million set aside to go to the CJCC, which is the Criminal Justice Coordinating Council, next year for grants for alternative courts, like the drug court that we had that's so successful in Troup County, like the mental health court that we're looking at putting into place. This is a significant help to the alternative measures that we know absolutely will work. The other important thing about this is it increases the amount of pretrial diversion fees, pretrial diversion fees from $300 to $1,000, so that people that are fined and plead guilty on pretrial diversions, they can also be paying about the same amount for the same event.
Okay. Thank you. This question is yours. In what specific ways could the criminal justice system be made more efficient?
Well, I took office 8 years ago, and we started taking a good hard look at this. From the perspective in state court, the things that we have already done, and I think we've done a lot so far, used to be that you came into state court and there would be multiple bench trials every month. Every law enforcement agency showed up at every single one of those bench trials because they weren't separated out. So you could have a law enforcement agent who was having to be in court 4 times a month dates of bench trials. We have toned that down a little bit. We have what we now call agency days. So LPD only comes one time a month. Troup County only comes one time a month. GSP comes one time a month. What that does is it makes the officers be able to get in and out of the court system, be back on the roads, or be on their off day if that's what's going on. We've also done some other measures. We have a non-English arraignment day. It used to be that if you had someone who didn't speak English, and we are having more and more and more of that, at different court days, it took up a significant amount of the court's time to deal with a person who might not be able to speak English and needed an interpreter present. It takes at least double time, sometimes triple time, to deal with that individual. Now we have all those once a month in the morning, and we're able to deal with it in a much more efficient way. It also helps the burden on the county in terms of the money, because it doesn't cost as much to have the interpreter come back just that one time per month. We are looking at all kinds of ways to increase the efficiency in state court. Every time we think of a way that we can do it, we implement it. Sometimes they work, and sometimes they don't work, but we keep trying to come up with new ideas and put them in place.
Repeat the question one more time.
In what specific ways could the criminal justice system be made more efficient?
Well, I think to improve efficiency, you've got to be prepared. From the moment the case comes into your office, you've got to gather all the facts, you've got to get all the evidence together, you've got to coordinate with law enforcement. And once you do all that, of course, you get the case filed. But being prepared is the main thing. Because if you're not prepared, when you get to court, what's going to happen? The case is going to get delayed, the case is going to get continued. As Ms. Baker said, officers are going to come back again and again to the court for the same case. It's going to drag on and on and on. So being prepared is the major thing. You know, a lot of times these cases come through, witnesses don't want to come to court. There's got to be a mechanism in place to where you can get them to court efficiently and effectively to prosecute the case. And so I believe just being prepared, more so than anything, is going to make the state court more efficient.